It is now with pleasure that I present to you His Excellency, Honorable Earl Warren, Governor of California.
Born in 1891, Warren was meant to become Chief Justice from the day he was born. As a child, Warren sat in on criminal court cases in his hometown, sparking his interest in law from a young age. As he grew older, he obtained a job working for a railroad company to start saving money for college. While this may seem unimportant, it is actually quite the opposite.
Warren's years working on the railroad were what shaped his progressive political and legal attitude because it exposed him to the corrupt conduct of railroad companies at that time. Warren would later attend law school at the University of California, Berkeley, and became a lawyer in 1914 until he enlisted in the Army during World War I.
Upon his return in 1918, he became district attorney and then the governor of California, where his progressive views shone through very clearly in his policies.
The governor made extensive use of civil advisory bodies to develop ideas for presentation to the legislature. Such conclaves were held on a variety of topics, including civil disturbances, crime, employment, mental health, old age pensions, senile patients in public hospitals, sex crimes against children, and youth welfare.
His popularity grew as he worked to fix major problems for a wide range of people regardless of their identity. His success and his views led to his appointment as Chief Justice in 1953 by Eisenhower, who once said that Warren
Represents the kind of political, economic, and social thinking that I believe we need on the Supreme Court. In 1954, the Brown v. Board of Education case declared that the ideals of separate but equal could not pertain to the schools. While this decision sparked a lot of resentment and violence throughout the country, it was a major step in the progress for the civil rights movement as it looked to give African Americans equal education opportunities. 9 years later, the Supreme Court case Gideon v. Ogden set forth the precedent that a criminal defendant would have the right to a lawyer, and if they are indignant, they would be provided one. Similarly, Escobedo v. Illinois allowed defendants to have access to their lawyers prior to police questioning, resulting in the police not being given the chance to take advantage of those unaware of the questioning process.
The extension of rights to the accused and the rise of a more fair trial gave Americans more protection under the law and made it so that legally it would be difficult to act with discriminatory beliefs. This would allow for fair trial for all criminals despite their financial state or ability to defend themselves to a judge or jury. In 1966, Miranda v. Arizona said that all defendants taken into custody must be told their rights by the officer arresting them. These rights came to be known as Miranda rights. These include the right to an attorney and the right to remain silent.
Warren's efforts to help move more people obtain a fair trial and his awareness of the common problems they faced engendered more trust in the overall justice system. Even though these court cases were unable to end racial discrimination within the court system, they did add to the protection of justice that was being demanded at the time. Along with creating a fair system against injustice, Warren also limited states' power in controlling contraceptives in the case Griswold v. Connecticut.
The case made it so that states were unable to put any sort of ban on contraceptives, which was a huge step forward for women's fertility rights within the sexual revolution for women, whether single, married, stay-at-home, or working, etc. Overall, Earl Warren's decisions in Warren Court were able to make extensive progressive changes pertaining to the revolutionary movements for rights.
However, today, the policing system continues to disproportionately target minorities. In New York City, 53% of people stopped by the police are African American and 35% are Latino, while about 88% of the total stops are of innocent people. In Chicago, the percentage of young black men arrested has risen to 79%.
We as a nation continue to live within a policing system that thrives on systemic racism. Warren Court set in place judicial roadblocks that protect the basic rights of marginalized and persecuted minorities by giving protection from unreasonable searches based on biased suspicions that guaranteeing an attorney, given that above 80% of criminal defendants nationwide cannot afford their own lawyer.
Acts of Earl Warren were one of the few pursuits of racial justice in the courts, laying the groundwork to protect targeted Americans from discrimination or unfair treatment under the law. Without these basic freedoms from oppression and strives towards justice, there would be an even greater amount of innocent people behind bars.